So welcome back, everyone, to another episode of Autism Labs. The last couple of weeks, we've talked to another dad of a profoundly autistic son and taking you through a little bit about that journey. But all kinds of questions have come up, right? Like, okay, my child's not quite as old as Sam was or Michael. What do I need to get ready, right? And questions like guardianship have come up, or special needs trust, or just financial planning in general. And so I have the privilege today of talking with Melissa Donovan, who has been doing this for a while. And in full transparency, we are a client of Melissa's law firm. So Brad Wewell, who's the founder, and Melissa and some of the team has helped us for many years navigate the rules and the regulations, whether it's guardianship or trust or all this other stuff. So I thought this would be a good conversation today with someone that actually knows a whole lot more than I do about all these kinds of things. So Melissa, why don't you introduce yourself, and then we'll get right into some of the questions that parents have had for us.
So like you said, I'm one of the attorneys here in Austin, our law firm. I'm a certified elder law attorney, which I always kind of joke makes it sound like I just work with the elderly. What it really kind of means is that my specialty focus is more so on government benefits. So special needs planning in general, across the board, from young kids to elderly adults, estate planning, all of those sort of things. But that's kind of where I focus, is more so in that special needs arena. A lot of work with parents with special needs children across a variety of arenas in terms of what disabilities they may have, and a little bit of guardianship work. So I'm kind of just excited to kind of talk and to see what questions y'all have and go through those with you.
Well, let's start with, I guess, maybe one of the things that's is easy, and that has to do with guardianship. We went through that with our son, and I know questions that come up with, like in Texas, guardianship is not automatic, right? That there's some rule, I believe, where the court has to determine, or someone has to determine, can your son or daughter, even though they're, quote, profoundly autistic or they have complex special needs, can they make decisions with some assistance, right? Which is different than full legal guardianship, I think. But can you just explain for everyone in layman's terms what the rules are, at least in this state?
Across the board, guardianship is not really automatic once someone's 18 in any situation. Of course, I know it might. I always kind of say, you've all heard like the Britney Spears stories and things like that. And some people get a kind of an idea that guardianship is something that's pushed. It actually, in the court system and in the community of people who work within special needs arenas, it's actually kind of more of we're trying to avoid it as much as possible. So I think what you're kind of getting at there is what we refer to as alternatives to guardianship. And it's a really important conversation, because when it comes to guardianship, the court has to be able to determine that the individual that you are trying to get guardianship over is incapable of basically making decisions and managing life the way I kind of like to put it, as a typical adult would. Now, many people would say no 18-year-old could make those decisions. So that's why we kind of say, like, no, we're not just going to grant a guardianship. It's actually more work than people say. Like, I tell people all the time, we only do uncontested stuff at our firm. So, I'm not dealing with a contentious litigator on the other side of things that's fighting me. Everybody is in agreement in the situations that we are working with, And even in that case, a guardianship case is going to take 4 to 6 months on average. It's a process. And we need to be able to prove to the court that, one, the person, your child that you're trying to get guardianship over, actually needs it. So they cannot make decisions. It is not safe for them to be able to make all decisions for themselves. And then also that the person that's trying to get guardianship is actually qualified to do so. It always kind of comes down to, across the board, anytime we're dealing with children or individuals with special needs who are incapable of making decisions for themselves, it is always looking at what is actually in the best interest of that person. So that's what we're trying to determine. Is it actually in their best interest to have that person as guardianship? Because it is a lot. I think a lot of people, not that they fail to see it, but we forget in guardianship, we're taking away that person's rights. So we want to think about that really closely. And the court, at least in my experience here, because I work mostly in Central Texas, Travis County, Williamson County, and they're really good about kind of balancing that out in what my experience has been here.
And you mentioned it's like a 4 to 6 month process. So when should you start? I've heard that you can't really start, well, maybe you can before they're 17 and a half, but probably starting when they're 17 and a half makes sense. What's your recommendation there?
So usually if I am working with a client, because a lot of the times personally in the clientele that I work with, this conversation is starting earlier on because they're coming to us to do estate planning. And many times that might be when their child is still 12 or 13 or even younger. And it's interesting because I see a lot of people even at that point that they already have questions about guardianship. So I always tell people that the time frame to really start considering it strongly is about 16 and a half to 17, but you're not going to actually start any of the actual formal processes, typically until about 6 months prior to the 18th birthday. For most of my clients that I work with in terms of that guardianship hearing, the goal is that we're trying to get the guardianship in place as soon as possible, as close to the 18th birthday. So the best way to make sure that you can kind of get that guardianship as soon as possible is to start that process about 6 months prior. So that starts with getting essentially the doctor's opinion. So we have what's called a CME. Most counties use the same form. So you have to have this form signed by the child's doctor where they are attesting to, what are their parameters? What's the diagnosis? What are they capable of doing on their own? What are they not capable of doing on their own? It's a pretty in-depth form. Not every county uses the form. I've done work outside of Travis Williamson County where in some of the smaller counties in the area, it's a little bit more lenient in terms of how the doctor's forms are coming in. But most counties, at least in Texas, use a pretty standardized medical professionals form. We call it the CME. That is the first thing. And that can be signed up to 6 months prior. So that's where you kind of get that 6-month date. In some scenarios, with guardianship, you can have the forms filled out prior to that, because if it's more of an intellectual disability, those intellectual disability determinations can go a little bit further back than the CME can. But for the vast majority of people that I work with, we're going to start that process of getting the doctor's letters about 6 months prior. And then once you start the process of having that, then you can start the application and then go from there.
So what happens if you don't do this and the 18th birthday passes and your son, like our son, is nonverbal? His IQ is, 40, 50, who knows? He doesn't understand emotions. He clearly can't make decisions on his own. And now all of a sudden he's 18 and a half and 19. What happens? Why is it so important to make sure that guardianship's in place?
Particularly in a situation like you described, what I tend to find, and probably what most practitioners or family, if you run into families, who deal with it, are going to tell you is, well, I've been working with the doctor and they haven't asked me for anything. And you run into that a lot if you're dealing with physicians that you've worked with for a really long time, or, counselors at school that are being very, what I would call, lenient. But essentially what can happen is that a lot of people, if you know them, are going to continue working with you. But you're going to run into the person that you don't know, is the way I like to explain it. You're going to have a new counselor come into the school, or you're going to have to deal with somebody in a third party setting, or you're going to have an emergency where you're going into the hospital for something else. And that's where they're going to say, well, we don't have the ability to share. We don't have the ability to tell you he's 18 or 19 or 20 or whatever age you get to before it becomes an issue. But eventually it's going to become an issue. So it's kind of like anything else. It's better to have it planned and ready up front and not deal with getting to the emergency where now we're stuck before you go, okay, well, now we're in this emergency and we have no ability to get information.
Right. And you mentioned a key word, planning. And so I want to sort of shift gears and talk a little bit about special needs trust and estate planning. This is a very expensive journey. And we've talked a lot about this on the podcast on different episodes that, if your son or daughter is nonverbal, whether they're diagnosed as profoundly or severely autistic, or they have some other diagnosis and they can't really be on their own, they maybe require care from the time they get up to the time they go to bed. The amount of money that's in play is unbelievable. And very few families have the financial resources to all of a sudden start putting that kind of money on the table when their son or daughter ages out of the school system at 22. So I know a big part of what you guys do, because you did it for us, was help us set up a special needs trust. Tell us a little bit about why that's important, when one should start doing that, what the benefits of that are.
So the purpose of a special needs trust is it's kind of twofold. It's to make sure that there's a vehicle in place. And for a lot of people, it is more so focused on what's going to happen when I die. Okay. Like, I've got money, maybe I've got 2 kids and I want to leave my money to them when I pass away. And how do I do that effectively? Because the crux of the issue is, if we have a child who's on Medicaid, who's on SSI, those are means tested benefits, the government doesn't allow you to have more than X amount of assets and income, et cetera. So if we want to leave that person money, we need to do it in a very specific fashion, which is special needs trust. I love and I appreciate so much about what you are doing here, and what a lot of people are doing now is people are a lot more well-informed now. I still every now and then get a client that comes into the office that maybe did planning 10 or 15, 20 years ago that is still under the impression I cannot leave anything to my child with special needs. The government says I can't do that. And so I'm leaving it all to my other kid or something like that. You don't have to cut out your child that has special needs. You don't have to not give them anything and give it all to their brother or whatnot. You just have to do it the right way. So the purpose of the special needs trust is that you have essentially a bucket of money that can be there for that individual. They can't control it. They can't they can't have the right to what we call make demands. So I can't have a trust that says I'm the beneficiary and you have to give me this amount of money. With a special needs trust, you are putting a third party in control so that that person has full discretion to provide for the person who's on benefits, to provide for the special needs individual. And then you can take care of, I like to call it kind of the everyday luxuries. So those things that most of us kind of just don't even think about. Like I'm going to run to CVS to get, eye drops or something like that. Or I want to go to the movies on a Friday night, anything like that. You can pay for anything like that from a special needs trust. You got to pay for the cell phone bill or whatnot. Contrary to a lot of people's understanding or belief, you can pay for housing and food and things like that out of a special needs trust. You just have to be careful how you do it. The purpose of a special needs trust, generally speaking, just kind of across the board, because there's variations on what types of special needs trusts we can have, is to have a place where there's money that can help that person without costing them the benefits that they're receiving. So we're not going to lose Medicaid.
And that's what I want to talk about is we'll lose Medicaid. So here is the, I think, misconception that some folks have, and you're right, I think more parents are better informed today than they were certainly when we set this up with your guys' help. And correct me if I'm wrong and elaborate as you see fit. If you have more than $2,000 in the bank in assets for your son or daughter, and you're receiving, waiver dollars, for instance, whether it's Medicaid through class or HCS or something like that, and that's discovered, you run the risk of losing that support forever. It's not easy once that happens, at least that's our understanding, to get back to the top of the list. And in Texas, that list is, 15 years or so. So is that true? Or are there some other considerations that come into play that you want to make sure parents are aware of?
So it does depend highly on what program someone's in. And that's across the board in any state, I know, whether it's Texas or anywhere else. In a lot of programs, it's not that you will lose it forever. You might lose it for a month until you can deal with it. Like, let's say someone just goes slightly over, or the example I use a lot with clients when talking about special needs trusts and why we might need to have different types of accounts and things, able accounts, whatnot, is, we get that kind of unexpected income. And I say income in the Medicaid fashion, not in the IRS fashion. Grandma, grandpa gives us a gift. Someone unexpectedly passes away and left a $5,000 distribution to the person. Those are things that able accounts are really good for. And if we can get the money out of the account very quickly, you can get it back. But there are certainly other programs where, to your point, if we are potentially going to lose a program that is a 15-year wait list, we want to be very, very careful of that. I mean, that being said, I kind of mentioned it earlier. I am a really strong proponent of able accounts when used effectively and appropriately, because that's a good tool too that can be utilized.
So let's talk about able accounts and when one should have an able account. What is an able account? How do you set up an able account? Why you would want an able account and a special needs trust? Just cover that, if you would, at a very high level for everybody.
So able accounts, the easiest way that I have found to explain them, because most people I find are pretty familiar with them, is able accounts are essentially a sister to 529s, college savings accounts. They're set up under almost the same kind of general guidelines, with the exception being, 529s are for school, they're for educational expenses, and able accounts are structured to pay for what we call qualified disability expenses, which is essentially a fancy way of saying the things that we need to make sure that you have a better quality of life, because that's literally what the law was put in place for, so that there is an ability to have an investment account or a savings vehicle. And in some situations, for the right candidate, so if we have someone, the example I always give is, let's say we have someone who has a physical disability, but they are perfectly capable of making their own decisions from a mental standpoint. For many, 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 many decades, they had no ability to have any control over anything more than, to your point, $2,000 in a checking account. So this law was kind of created initially for that purpose, to be able to kind of give people back a little bit of a sense of autonomy, that they could have a little bit more money saved up that they could use. In practice, at least in my own practice, because I tend to, again, be doing more special needs planning with parents, they're a really good tool, because you can do things with an able account that if you were to do them with a special needs trust, you could potentially lose some of more so your SSI benefits for people who are on SSI. So it's a really good tool. I use the example of, let's say we've got $5,000 that come in as an inheritance. If I have an ABLE account, and let's say it's more in a situation where that child, the special needs individual, does not have that mental capacity to be managing the money, if there's a guardian, the guardian can be in control of the ABLE account. And it doesn't have to be a guardian of the estate. It can be a guardian of the person that is in charge of the ABLE account. In order of opening it up, it could be a parent that opens up the ABLE account, even without an actual guardianship in place. But it gives you the ability to have a sum of money that could potentially be invested and grow. And I say could potentially for a reason. I can kind of come back to that. But if I get that $5,000 gift on, February 10th, and I need to make sure that I use that money before the next month starts, but I have no ability to use it on anything that you really kind of want to use it on, you can swing that money from the checking account over to the ABLE account, and then it kind of disappears. Because what happens is you can have the account, there are financial limitations on it, but if you put money in there, it can be used to pay for almost anything. I mean, I have a list that I tend to give our clients of, this is what we can use the special needs trust, and this is what you can do with a qualified or with the ABLE account, but you can pay for housing. The biggest one is you can pay for housing from an ABLE account and not lose any SSI. Whereas if you do that from a special needs trust, the beneficiary is going to lose a small portion. Well, it's really not a small portion of their SSI. It could be a small portion of what you're paying for rent. You can pay $5,000 for rent. You're going to lose about $380 of the SSI check. So basically it's a third of the SSI check that is lost, but you can pay from a special needs trust any amount that you want, but you're going to lose that. If you can fund that money through an ABLE account, so like we use these in conjunction with our special needs trusts a lot, because you can take it from the special needs trust, fund it to the ABLE account. And then you can use the ABLE account to pay for rent if it's under a certain amount of money. And then that beneficiary is not going to lose any SSI at all. But it's a really helpful tool. And then of course they can use the ABLE account for school. They can use it for, professional fees. They can use it for, anything, like I said, that gives them a better quality of life. And that becomes really helpful, both in the sense of, okay, we've got a place that we can put money. If I call it an emergency, we've got extra money that we're not going to use by the end of the month, or I've got a beneficiary who actually could manage money on their own, but the government, because they're on these means tested benefits, doesn't allow them to have more than X amount of money. So they're a really neat tool to use, but you do have to be careful in how you use them.
And so a couple of the rules that I'm not clear on ABLE accounts is there any limit on how much money you can put into an ABLE account per year? Mm-hmm. And is there a cap of like $100,000 or something? That's the most you can put into an ABLE account.
So in terms of caps, so annually you can place into, from all sources, so not one person, everybody gets one of these, but if mom and dad, grandma, grandpa, brother, sister, everyone who is contributing to the ABLE account can put in the equivalency of what that year's gift tax exemption is. So right now that would be $19,000 a year. Frankly, I would never recommend using it that way, but that's kind of your annual cap. There are some more expanded rules where if the actual beneficiary is working, you can utilize it for a sum of their income up to the poverty limit, but that's not how I see most people using it, truthfully. In terms of kind of lifetime caps, you can have up to $100,000 before you lose SSI. Then each state has a secondary limit. So if we go over $100,000, we get to $100,000 and 1 penny, we will lose SSI until that money comes back down. If we are in a Medicaid program at the same time, which if you're on SSI, you're going to be on Medicaid as well. If you are in a situation where you can maintain that Medicaid, you could have potentially over 100,000 and continue on Medicaid, but that is then capped. In Texas, it's $370,000. That does vary state to state, depending on those rules. That being said, ABLE accounts also have what we call a Medicaid payback provision, which means any money that's left in the account when the beneficiary passes away, the first place it's going to go is to the Medicaid program to pay back any of the things that they have paid out on behalf of that person. So this is why you heard me say earlier, you could do this. I don't really recommend that you do use it as an actual savings vehicle. I tend to suggest that you think about it more like an emergency tool. It's a great place that we can funnel things through, or it's a great place to have in case we get those, unfortunately, what we consider emergencies in this particular scenario, be a blessing at the same time that they can be a little bit of an emergency. So if we do get that gift, or we have more money in the checking account than we should close to the end of the month, we can swing that money over to the ABLE account. But I don't typically suggest that you think about the ABLE account as, oh, this is just a different savings vehicle and everybody can gift money to this on a regular basis. Because then you're just accumulating funds that if they can't be used, it's all going to go back to the state, which is not necessary because you could better utilize a special needs trust for that. So it's just about balancing the different tools.
Right. And so I think most parents that are listening to this now have this idea, if you haven't already, this is not simple stuff. And yeah, you can go to AI and you can do a query at ChatGPT or Gemini or Claude, but the subtleties and the nuances of how you actually set this up and the layers of income, right? So we've been talking about SSI, and we haven't yet talked about when can you start getting SSI? What's the difference between SSI and SSID or SSDI, whatever it is? We'll talk about that in just a second. Have hopefully some waiver dollars coming in if you've gotten to the top of the list in Texas. That can be class waiver dollars. It can be HCS waiver dollars, maybe other types of waivers depending upon your disability. You have ABLE accounts. The reason this is all so important, and we actually felt guilty, Kay and I did, that we have financial resources, and our feeling was we can pay for our son, and we take pride in our ability to pay for our son as he grows up. But the costs can be millions and millions of dollars over someone's lifetime if they're needing one-on-one care, if they have multiple disabilities, and the money's there. I mean, it's actually there for a purpose to make sure that the quality of life of that person's maintained. And so taking advantage of Social Security when you can get it, taking advantage of putting money into an ABLE account, setting up the special needs trust so that you have multiple revenue sources, multiple financial instruments in play. So if something unforeseen happens, God forbid you have cancer and you pass away sooner than you thought you were, that from a financial standpoint, at least, your son or daughter is hopefully taken care of. So let's dive back into SSI and SSDI or whatever it is. Can you just explain briefly, Melissa, what benefits one's entitled to, what the differences are between those two, and anything else that you think is important for parents that, they've heard about Social Security, they're not sure exactly when they can get it, how much they can get, what the limits are, should they wait and get more later, what all that confusion is, and any clarity you can provide would be great.
So SSI, SSDI, in terms of qualifying for them, the baseline from a medical point of view is going to be the same. You have to be able to show that you are unable to, I have repeated this phrase to myself since I was in law school a very long time ago. You cannot do substantially gainful employment for a period of 12 months or longer. So when we're looking at SSDI is associated with people who have worked. So SSDI, on top of that baseline medical, the difference between SSDI and SSI is that if you are applying and getting SSDI, that means that you have work history. And in order to be able to qualify for that, you have essentially 10 years of work history. 40 credits is what they refer to it as. A credit is accumulated once a quarter. So if I have 40 credits, I've paid into the system. And in most situations that I have dealt with previously, in a previous life, I worked for a Social Security firm when I was in law school. Those are people who worked and then became injured. They either became injured or they had a degenerative condition that just got to a point when they were maybe in their 40s or 50s that they could not do it anymore. That's SSDI. I am medically qualified for this benefit because I cannot perform gainful activity. I can't work. And I have enough work credits I've paid into the system, so I'm getting paid back from that insurance program, essentially. SSI, supplemental security income, covers anything else, essentially. So if I'm on SSI, that means that I have either limited or no work history. I'm not paid enough into the system to qualify under SSDI, or to become even more complicated, I may have worked enough credits to have SSDI, but my income level was low enough that my SSDI is lower than what the SSI limit is. So now I have both SSDI and SSI. This is where it gets really confusing, kind of complicated. But SSI, from a financial perspective, SSI is capped. Okay, they're both capped in a way, but SSDI is going to be based on what your income was. So you might have someone on SSDI getting, $1,800, $1,900, $2,000 a month. SSI is going to be capped currently at about $995 a month. So it's not a ton of money, okay? And there's a lot that they expect you to do with $995 a month, So this is kind of why I said earlier, there are certain things you can do with special needs trusts versus ABLE accounts. But with SSI, You can apply for SSI if you meet the definitions of being incapacitated, being disabled according to Social Security rules. You can apply at 18. You're not going to apply before 18. You're not going to qualify for these. Not everybody, but most of my clients that I work with are not going to qualify prior to 18 because they're looking at your parents. When you're looking at Medicaid and SSI under the age of 18, it's a completely different ballgame than when you turn 18, because going back a little bit to the guardianship conversation earlier, as soon as you turn 18, it's like 11:58 on this day, I'm a child, and 12 o'clock, I'm suddenly an adult, and my parents don't have anything to do with me when other people are looking at me, right? It's like a weird thing to think about. Like 2 minutes have passed and my whole thing has changed. But if I'm 18, then they don't look at my parents anymore. So if I am the incapacitated child, that's where the parents are going to start to think, okay, what are we going to look at? I usually tell my clients, if we are in a situation where it's pretty clear that their child's going to qualify for those benefits, then I'm going to be telling them you should start that application process immediately after they turn 18. Now, what I will also say is it doesn't matter how qualified you are. Most people are going to be denied the first time around. I don't do that kind of work anymore. There are certainly Social Security disability attorneys who do great with the actual application process, but you can apply for SSI as soon as you turn 18.
Hey guys, I want to stop this episode at this point. Melissa's got a wealth of knowledge. We're going to continue next week. There's so much to talk about. She's a great person to talk to, whether it comes to ABLE accounts, and we're going to be continuing this conversation about other financial vehicles. So please come back next week for a continuation. In the meantime, please take care of your child, your son or daughter who's profoundly, severely autistic or has complex special needs. And of course, take care of yourself too. See you.